In Illinois, the vast majority of professional and occupational licenses are issued by the Illinois Department of Financial and Professional Regulations. This department issues licenses for everything from real estate brokers to registered nurses to barbers and nail technicians. All applicants, regardless of the license they're applying for, are asked 2 questions regarding their criminal history. Have you ever been convicted of a crime? The second question asks, have you ever been convicted of a felony? Answering yes to either of these questions is not an automatic bar to obtaining a license, as it is in some states. However, it is critical that you answer the question truthfully, or your application will be denied. If you've answered yes to either criminal history question, you can expect that the department will request additional information regarding that conviction history. Whether or not you've sealed that information has no bearing in the license arena. So unlike an employer who is barred under state law from asking you to disclose a record that's been expunged or sealed, that prohibition does not apply to the Illinois Department of Financial and Professional Regulation. The Illinois Department of Financial and Professional Regulation will take several factors into consideration in deciding whether somebody's conviction history should be the basis for denying their application. Consideration of the type of offense the person's committed, when it occurred, the age of the individual, when they committed the offense, whether the offense has any relation to the duties of the profession or occupation. And then in particular, the department is concerned about any crimes involving dishonesty, such as forgery, theft, retail theft, as well as any crimes relating to substance or alcohol abuse. There are a few things you can do to facilitate the department's investigation into your criminal history. You can petition the state court in the county where you committed the crime to obtain what's called a certificate for relief from disabilities. The certificate does not guarantee that you will get the license, but it is evidence, objective evidence of your rehabilitation. The certificate only applies to 27 licensing statutes. If the license you're applying for is not one of those listed on the certificate for relief from disabilities, another way that you can assist the department is by putting together a detailed written narrative describing the conviction, your criminal history. Along with that written narrative, you would also want to attach relevant court records pertaining to that case. It's helpful to have an attorney assist you with this, because the one thing you don't want to do is misrepresent or misstate any of the facts pertaining to your criminal case. The department may ask you to appear for what's called an informal hearing. And what that is simply a meeting where you will sit down and speak with 2 or 3 members of that licensing board and possibly an attorney with the department. This gives them an opportunity to meet you in person and ask you any additional questions they might have about your history. If the board denies your application at the informal hearing, that triggers your right to request a formal hearing before a hearing officer. And then at the end of that hearing, the hearing officer will draft a written decision, either granting or denying your license. At that point, if the license application is denied again, you still have the right to file for administrative review by going into state court. Addressing your history fully and squarely will send the message that you don't have anything to hide, and that your qualifications more than outweigh any mistakes or errors in judgment you've made in the past.